Okay, get started. Hello to everyone who's joined. Thank you for joining. Welcome to this, a practical guide to dispute resolution webinar hosted by SES legal patrons Mills Selig. Court proceedings, of course, can be daunting prospects. So here to provide insight, we're joined by two of Mills Selig's expert team, Rebecca Logan and Conor Mulligan. Rebecca is Senior Associate in the Litigation Team at Mills Selig and has significant experience in dealing with a large variety of commercial disputes for clients. Conor is a construction solicitor who is frequently involved in mediating high-value construction, engineering and procurement disputes. So very happy to welcome them. And just to say there'll be time for questions at the end. There's a Q&A chat function there, so please feel free to pop in any question. And as I say, we'll come to this at the end. So happy to hand over yourselves, Rebecca and Conor, to take it away.
Yes, thanks, Vincent. Thanks for the introduction. Hello, everyone. Thanks for joining us this morning in our latest webinar of this series. Yes, I'm Rebecca, Senior Associate in the Commercial Litigation Team here at Mills Selig. Cover a whole range of commercial disputes for businesses, construction disputes, contracts, intellectual property, property disputes. And I'm joined by my colleague Conor here, who works in our construction team. I'm sure you're all more than familiar with the work that Mills Selig does, but just very briefly, we're a commercial law firm, full service, so can cater to all business needs really. So today we're going to cover the dispute resolution process and hopefully provide you with more of a practical guide if you're ever faced with a commercial dispute. It's not something that people tend to expect or wish, but it's a sort of an inevitable consequence of running a successful business, is that you are going to come into disputes here and there, and it's always good to be prepared as to what to do to fully protect yourself. So we're going to hopefully cover that and stay away from all the boring bits. Things that the lawyers need to worry about, and focus more on the practical, a practical guide for you. I'm going to cover more the legal proceedings through the High Court, and Conor will come in and talk us through the adjudication process, which will be more specific to construction businesses. So we'll go through what to expect, what your initial considerations should be when faced with a dispute, either as a plaintiff or a defendant. I'll outline the court process, specifically with the High Court, but a focus on the Commercial Hub, which is a division in the High Court. What the legal remedies might be, i.e. what you're trying to achieve through your legal dispute, what those options are. Of course, the issue of costs, which is usually the main concern for parties that embark on litigation. So I'll talk us through the general position and the general rules on the recovery of costs, what to expect if you win or lose. And then finally, what are the alternatives to litigation? So even if you are faced with a claim that's been issued against you, or the other way around, trial is not the only option. There are plenty of other ways and means to settle a dispute that can save a lot of costs in the long run. So yeah, why might a dispute arise? And there's a whole host of reasons, but the main ones really on the screen that might be relevant to you today: breach of contract, tort, a claim in negligence, breach of statutory duty. That could be breach of the defective premises order, for instance. A simple debt claim, you may be owed money from a supplier that isn't paying up, and the only option is to issue proceedings. Fraud, misrepresentation, that can happen. It's very rare, but it can happen. And personal injury, for example, an employee at work is injured. So if any of those things arise, or you feel that a dispute is about to happen, what are your initial considerations and what you should do if faced with that. First one, of course, and it may be obvious, but take early advice from your solicitor. If you don't have that go-to solicitor, then Mills Selig are, of course, here to help. Take that early advice. Don't try and deal with it yourself. Your solicitor will be there to advise you in the practical steps as to what you should do there and then to fully protect your position and advise you what you should and shouldn't do. Another obvious one, but something just to bear in mind, is to check your insurance policy, check with your broker. Is this something that you have cover already for? Sometimes if so, the insurance company will have panel solicitors that they would tend to use for particular types of disputes. So your usual solicitor might not even be required. And in that case, their legal fees would hopefully be covered by the insurance policy. And another key one to remember is just gather and preserve all relevant correspondence, documentation, anything at all relevant to that dispute. Your solicitor will ask for that as soon as it's all available. They can work out what's not relevant from what is, and it's just important to be completely open with your solicitor and don't hold anything back. More technical legal points really, also for a claim to get going, is whether it's out of time and where it could be, where the dispute can be litigated. So limitation will cover in a later slide, but if it's out of time, then it won't get off the ground. Sometimes, there are plenty of arguments around limitation, but it's the initial thing to check. When did the breach occur? How many years down the line are we? And is there a contract that might say that you're too late to bring a claim? For example, a warranty claim, they're usually time restricted jurisdiction. Your contract should hopefully have a clause in there that tells you where the dispute is, but it might not. This is a question for your solicitor to answer, but where is the jurisdiction? So you may do work in England, Wales, Scotland. Where is the defendant based? There are all sorts of considerations. So it may not just be Northern Ireland. In that case, if your dispute is outside this jurisdiction, then a solicitor based in the jurisdiction will need to be appointed as well. And then finally, is it worth taking the risk of bringing a claim? There's all sorts of factors to consider there, whether it's worth damaging any potential working relationship you have with the other party. Is it something that might not look favorably to your company in the media, for example? And also the risk of litigation. Is the cost worth the risk or the ultimate benefit to bring in litigation? So these are all the initial things you should be thinking about. So limitation, like I say, just very quickly, I'll not go into the law, but as a general rule, you're out of time for breach of contract claim after 6 years from the breach. Same with tort, a claim in negligence, 6 years from the breach or 3 years from the date of knowledge. So it's a latent defect that nobody was aware of, but it was uncovered. You have to act within 3 years of the knowledge of that breach. There's a 15-year long stop period for that, so it's not indefinite. The knowledge has to be within that 15-year period. Same applies for the breach of statute duty, like say a claim under the defective premises order. That's also subject to that 6-year term. And for personal injury, it's 3 years from the date of injury. This just gives you a very basic overview of our court structure here in Northern Ireland. Really, we're focusing today on the High Court, but this just gives you an idea of what else there is. So above that, of course, Court of Appeal and the Supreme Court. High Court has jurisdiction to hear claims valued over 30 grand. And there are 3 divisions, but we focus today on the King's Bench division, formerly the Queen's Bench, and that's where the commercial hub sits. So this is what we're focusing on today. So very generally, the way a case would proceed, or how it would flow through the court process. The initial stage is pre-action, and there are all sorts of protocols depending on what type of dispute. But if we focus on commercial disputes, there is a specific pre-action protocol that sets out the steps that you should take. Now, if limitation is an issue, and say you're under pressure, limitation might expire soon, you can issue your proceedings, but the courts will probably expect you still to stay those proceedings, go back and carry out this pre-action protocol. So it's basically engaging early with the other side, exchanging correspondence so that the other side is aware of all the facts and the basis of your claim, so that they can properly engage with you. And the idea behind that is that hopefully that exchange of early information can help settle disputes, and litigation should then be the last resort. This really entails writing a letter before action or a letter of claim. The other side will have a period of time in which to respond to that, and then that's usually followed by a meeting of the parties. Now, if that doesn't resolve everything, then you are entitled to go ahead and issue your proceedings. Now, it'd be at that point where we would appoint counsel, so your barrister, who would then be the person to conduct hearings, the trial, and prepare the documents and pleadings. Now, that decision can be made collaboratively with the client, but typically we know our barristers very well here in this jurisdiction, being such a small place. We have a fair idea of who is best suited to different types of disputes, and can then advise you accordingly. Depending on the value of the claim, you may require a KC, formerly a QC, so a senior barrister, who would then be accompanied by a junior barrister. So junior barrister is really anyone who's not a KC, and the two would work in tandem together, depending on the value of the dispute, but typically you may just decide to appoint one. So as soon as proceedings are issued, if it's a commercial dispute, so that would involve construction disputes, building disputes, things like that. The definition of commercial dispute, we would tend to advise that you consider applying straight away to transfer that case from just the King's Bench division straight into the commercial hub, which is a separate standalone court. And there are lots of benefits of doing that. It's much more streamlined, and it's much more focused on delivering for the commercial party. I'll go into more detail later on in the slides, but that's sort of the next step that we would tend to take. It just costs the same court fee again, 242, very small in comparison to England and Wales, where you're talking 10 grand for to issue a claim valued over 200,000, and here we don't have limits, it's just £242. So you then move on to pleadings, so that's your statement of claim, your defense, blah blah blah. So that kind of thing is something for the lawyers to worry about. Discovery, that's far more involved with the client. So this is something that's very important to bear in mind if you're proceeding with litigation. Your obligations for discovery, these are very important, and if you're found to have breached them, there can be very serious consequences for that, including perjury. So you need to be aware that everything is discoverable if it's relevant, even if it hinders your case. And it's something that's can tend to be quite hard for some clients to wrap their head around. But if you do uncover something that says that you have done the thing that you're being accused of, then if it's not privileged, you have to hand it over. So there are exceptions, of course. So like if it's privileged, so if you've said that in an email to your lawyer, that's not discoverable because it's protected by legal privilege. Also, if it's irrelevant, it can be redacted. So say you have a document that's full of commercially sensitive information and it's not relevant to the dispute, then you can redact that. But the general rule is that everything that's relevant must be provided, even if it helps or hinders. And that applies to the other side as well. Obviously, the aim there is for the courts to get to the truth and the justice. So I have a case study later on in the slides to talk you through. And in that case, something was left out of discovery, and there was cost consequences for the client. Expert evidence tend to be very relevant, especially in a construction dispute. You would probably need more than one expert. For instance, for liability, you'd probably need to appoint either an architect or an engineer to give us an expert opinion on what they say is the problem. And then also someone to advise on quantum, so usually a quantity surveyor, and you would appoint those. The other side would also have those, and the experts are hopefully supposed to agree on a position which can really assist the court outside of the legal sphere. Alternative dispute resolution then, once you get all of the, everyone has everybody's documents, the experts have given their opinion. Usually at that stage, parties are ready to then negotiate through the likes of mediation. So we'll go into a bit more detail later on. If that fails, then you're on to the trial, where you will probably then need to give evidence in the courtroom and any other witnesses that are relevant to the case. So these days, it's much more flexible and formal. Really, out of COVID, the courts have now all gone online. So you can watch the trial over this platform called SiteLink. You can also give evidence over SiteLink. So if you can't actually physically attend, there are ways around that now, which is actually a really positive thing that's come out of the pandemic. You'll then get a judgment, and you'd like to expect that judgment is then complied with by the other side. So say, for example, it's a money judgment. So say you're owed a lot of money from a supplier or a customer and they don't pay it, then there's means and ways to enforce it. And usually that's through the EJO, which is the Enforcement of Judgments Office. But obviously there are other options like insolvency proceedings. So the legal remedies that are available to you, this is very much one of those initial considerations as to what you're trying to achieve, what are you entitled to. So that can just be a straightforward compensation or damages that would put you back into the position you would have been in had the breach not occurred. The court can also order specific performance of a contract. So say another party isn't complying with the terms, you can also ask the court to order specific performance, but that's discretionary. Damages would be the alternative to that. Another big one is an injunction. This is something that would actually be before you issue, well, it's a type of issuing of proceedings, but you're basically making an urgent application if that's the case, and then the trial and everything else comes afterwards. But this is where there's something urgent that needs action. So an injunction is designed to make someone do something or stop doing something. And it's where damages would not be a sufficient remedy. It would be an inadequate remedy. So there are tests that and hurdles that you need to climb. But it's something that's there to that can be very, very useful if something urgent needs to be stopped. So really the most recent example we have, we had protesters outside of a client's office intimidating staff, and we were able to get an injunction very quickly to prevent them from doing so. And if a party breaches an injunction, you can be fined in contempt of court. So quite serious consequences. So that can include a fine or even in prison. So the commercial hub then. So like I mentioned before, this is a section of the High Court, and it's a relatively new creation, but it's evolving all the time, and it's trying to be very modern but also model itself in the English and Welsh system of the 3 case management stages to keep cases on track. Because here in Northern Ireland, cases can very much get bogged down in the review process. So if anybody is familiar with running a case through the courts, you might find that you're going into review after review, a party hasn't complied with the deadline. So say they have an outstanding defense, the courts, you go back to the court for review, tell the judge, and they'll say, well, 4 weeks, and then come back to me. With the commercial hub, they're much more tighter in deadlines, and they actually encourage other parties to sort of tell on each other. So if they think that they're not going to get, if the other party's not going to meet the deadline, or they haven't met the deadline, let the court know. And you face the wrath of the commercial judge. So everything's supposed to be electronic as well, electronic bundles, electronic court file. That sort of came in June this year, but nobody is paying any attention to that. I think everybody sort of likes the old-fashioned physical bundle. So we're still in the process of, copying thousands of pages, and everybody has a bundle each. Hopefully it will move to that, where everybody's just got an electronic version on their screens. They'll save a lot of time and cost down the line. But old habits die hard. There's the option to short circuit discovery as well, and for an order for specific discovery rather than just generate everything that could be relevant. So that's another way that it can quick. Expert evidence is usually always required, and the courts aim to have a 6-week turnaround for judgments, which is really good, really quick. And we recently had experience of that actually being the case. In comparison, a case that we had, actually it was in the county court, but 11 months it took us to get the judgment from the judge. So there are many benefits of using the commercial hub. So if your case falls in within the category of commercial dispute, that would be our advice to clients, is think about that application to transfer it into it, and it's well worth doing. So it's designed to be efficient and cost effective. So that case that I mentioned, we recently had a successful outcome for a client who we went straight into the commercial hub for them. They had about a 300 grand dispute. They were a supplier with a very bespoke contract with the producer, where it's quite an unusual term in that the producer was to cover all cost of production of this product. But in exchange for that, the producer had a constant supply of that product at a certain quality. So there were benefits for both sides, but they couldn't agree on the payment mechanism, and the supplier was really struggling, weren't getting their costs met by the producer. And so they had no other alternative but to issue proceedings. They had an expert determination or a dispute resolution procedure set out within their contract, which is something you might be familiar with. For instance, it might mention adjudication, arbitration, or in this case for us, it was an expert determination, where you should try that before you proceed to litigation. And in that case, we appointed an independent accountant, a forensic accountant. Both parties agreed that it wouldn't be binding. So you can make that decision before, whether it's binding or non-binding, or open or without prejudice. In this case, the parties decided it wouldn't be binding, so there was the option to proceed if you didn't like the determination that was made. We issued proceedings in November and issued what is referred to as an endorsed writ of summons, which is basically where you throw everything in at the once. So you're basically your claim form, your particulars of claim. In this jurisdiction, it's called a writ of summons, and your statement of claim, and that basically starts the clock ticking right away. So 6 weeks for a defence. we immediately applied to transfer it to the commercial hub, and we got an expedited trial date because we told the judge at the outset that our client would not survive if the defendant continued to breach the terms of the contract, and so they needed a decision. And he listened and took evidence from an accountant on that, but listed our trial for June. That was a very tight time frame to get everything done, pleadings, discovery, but we got there and judgment was delivered in 4 weeks. Now, that is quite an extreme example, but it can work that way. And now what the downside was, though, of course, there wasn't as much time as you might expect in another case for the likes of your discovery process. So while on the stand being cross-examined, one of the representatives of our client actually started talking about a document or a range of documents that he thought, oh, actually this might have the answer. And the judge immediately stopped proceedings, said, hold on, has this been disclosed? And after some sort of awkward exchanges between us in court, we realized that these documents had not been discovered or disclosed by us. The judge immediately ordered an adjournment of the trial for the parties to go away and provide and deliver up that information. Turns out it was relevant to the case, but it didn't change the direction of it. But the fact that that wasn't discovered when it should have been, it caused that delay in court. It required us all to come back again another day. When our client was ultimately awarded judgment in its favour, when we argued about costs, the judge actually deducted 20% from what they would have been entitled to recognise that for that failure to disclose documents when they should have. So just sort of a word of warning. So this was an extraction from the judgment. Now, I don't put that in there to blow our own trumpet, but it does. But I do quite like the first line there. Basically, it's just to demonstrate. The judge said, given that this case has now been heard and determined within 7 months of the writ of summons being issued, this represents a paradigm example of how the commercial hub can work in practice. So it's just it just shows you that the commercial hub can work as designed. So I guess most importantly, what's the position on costs? And this is usually what clients are most concerned about, and rightly so. Costs can mount very quickly, especially when you have counsel appointed experts and you get through all those stages and all the way to trial. It can be a very costly process. So the general rule is that costs follow the event. And that typically means the winner has their costs paid for by the loser. That's usually the case, but there'll be arguments about it, and the conduct of the parties will be taken into consideration. So now, that being said, it's not all costs. It'll usually be reasonable costs. So expect to recover 70 or even 65 to 80% of your costs if you're successful. Pre-action costs usually are not recoverable. So all that time that might have been taken at the start to exchange pre-action correspondence or go down those routes of expert determinations or anything that might be required in your contract, dispute resolution mechanisms, usually is not recoverable. So it's just something to be mindful of. As I say, the conduct of the parties can be taken into consideration. So a good example actually is the Vardy-Rooney case that I'm sure you're all more than familiar with. And as you know, Rebecca Vardy was unsuccessful in her case. And so the matter went to costs, and both sides argued their bit about who should recover the costs in that. Of course, costs followed the event. So Rooney was entitled to her costs to be paid by Vardy. But in this case, this was actually quite unusual. The court has the discretion to award indemnity costs, which actually would cover all costs, whether they're reasonable or not. And this happened in this case. So the judge actually ordered Vardy paid 90% of Rooney's costs on an indemnity basis, which is quite significant when you know how much both ladies spent in this case. What took the case out of the norm and what justified indemnity costs was the finding that Vardy and her former agent had deliberately deleted or destroyed evidence. So that was a really interesting one, and more of an extreme example of how the conduct of the parties can be taken into consideration. Calderbank offers, this is something that you may or may not be familiar with, but used quite frequently here in Northern Ireland. It's a type of offer, written offer to the other side to settle early. And it can usually put a lot of pressure on a party, especially if you're the defendant. You can offer to pay a sum of money to the plaintiff to settle the case. You usually make an offer to pay some of their costs as well. And if and it's usually open for a period of time, say 7 or 14 days, after which it will lapse. If the plaintiff doesn't accept and it moves on to trial and that plaintiff does not beat your offer, so say you've offered 100 grand and they only get 90, then they haven't beaten your offer. They should have taken it and they should have seen it, and it would have saved everybody's time, and it didn't actually require going all the way to trial. Then they can be penalised for costs up from that date, even though they've won, even though they get money from the other side. They might, I say might, the court's always got a discretion on costs, but the pressure there is from the date that that offer could have been accepted, you may not be entitled to your costs. So that could be substantial. So it's one of those tactical tools up a party's sleeve that can be used in appropriate circumstances. And then if costs can't be agreed, so what a judge will usually order is that the loser pays the winner's reasonable costs. But if they can't agree, then it moves to taxation. So we always advise that it's far more beneficial to agree those costs with the other side. So in that case study there that I mentioned, we managed to do that. You do have to take a bit of a hit, but the benefit of that is that you avoid taxation. So if you can't agree, this is another, so you apply to the taxing office, and the taxing master then makes a decision as to how much of your costs you should recover. And that can be a very slow process. And so we usually avoid it at all costs. Now, one thing I would say is the paying party. So the loser essentially has to pay for the process of taxation. So it's also in their benefit to avoid it as well. But if they think that your costs were ridiculous, then they can dig their heels in, and it can be quite difficult at that point to force it. So that's costs. Now, alternative dispute resolution, or ADR, is a way to avoid all of that. So to avoid going to court, to trial, and risking everything based on the judge's view on the day, the costs of that as well. This is very much encouraged by the courts, and it's part of the conduct of the parties that they would consider when looking at costs. So did parties engage in alternative dispute resolution? So expert determination I mentioned earlier. Mediation is a very, very good option, and something that we would tend to advise or encourage in most cases. So mediation is it usually just involves the two parties attending on a particular day with a mediator who will try to really get the two sides to compromise. Really, a successful mediation is where both sides go away unhappy. But the benefits of that are that you don't risk those cost consequences of court if you lose paying the other side's costs as well as your own. So mediation can be well worth doing. Even if you can't settle on the day, it can really help bring the parties closer together as well. You may find a week or two later there's a change of heart, and that mediation has actually brought that about. So it's something to consider by sort of midway through proceedings where you have exchanged all the discovery, everybody's aware of all the issues, and you can sit down and actually, try to find some compromise position. Arbitration, typically not something that we would tend to see very often in Northern Ireland because you have the likes of the commercial hub, but it may be something that you have seen in your commercial contracts, that it's something an option for you. But I think if Conor has anything to say on that, I will pass it to him. But he's going to cover now for us the process of adjudication and how that specifically how that option is there for you as a construction business. So Conor.
Thanks, Rebecca. Thanks everyone for tuning in today. Just thought it was important to sort of touch on adjudication in a bit more detail, given its relevance in the construction industry and given that it's becoming an ever more popular method of dispute resolution. So adjudication is what is it? Essentially, it's alternative dispute resolution, and it's perceived to be a faster, cheaper method of proceedings in comparison to litigation. The construction industry is often faced with strict time schedules and limited budgets, making steady cash flow an important element on any project. The nature of adjudication promotes a pay now, argue later approach, which allows project construction work to continue, and that in turn supports cash flow. However, adjudication, it shouldn't be looked at lightheartedly. Depending on the case specifics, adjudication can be really complex with detailed submissions, witness statements, and even expert reports. So moving on to how does it work? The Construction Contracts Order 1997 grants a party to a construction contract the right to refer a dispute to adjudication at any time. Construction contract can be interpreted quite widely, and agreements need not always be in writing. We are, however, seeing more commonly that there's specific inclusion of an adjudication clause when parties are drafting and entering into contracts. These clauses usually set out the party's ability to refer a dispute to adjudication, and what nominating body shall appoint the adjudicator. So RICS is a good example of a nominating body that we're seeing included in a lot of contracts. I think it's worth mentioning as well that you can't contract out of adjudication because it is a statutory right. So moving on to when is adjudication appropriate? Adjudication is appropriate for all types of construction claims, and can be used for resolving claims relating to interim payments, delay and disruption, extensions of time, defects in the work, and even more complex claims like a breach of contract or professional negligence. There's no restriction within the legislation which limits the scope of dispute that can be referred to in adjudication. So what does the process include? Well, basically, first and foremost, and maybe it's a bit obvious, but there has to be a dispute. And you can only refer one dispute under one contract at one time. However, again, that's considered a bit wide by the courts. So, there can be a lot of items involved in one dispute if you can categorize that dispute as how much money does one party owe the other. That dispute must have crystallized. And then following those first two hurdles, you will have your first formal document of the proceedings, which is the notice of adjudication. And that sets out the parameters of an adjudication. It's really important to get this document right because that sets the boundaries for what the adjudicator can decide. And that's where the right legal advice can be the difference in winning and losing. If an adjudicator decides something that's not included within the notice, then you can use that in an argument to set his or her decision aside. The appointment of the adjudicator is another important point because this is done through the nominating body, and adjudicators, they can have a wide variety of backgrounds, and the pool of adjudicators that we're seeing most can include barristers, engineers, surveyors, and even solicitors. And again, this is where you kind of need to pay attention to the detail, because if the adjudicator is wrongly appointed at the outset, there's grounds again to set his or her decision aside at the end. Following the notice of adjudication, you will have the referral notice. So that's a bit more of a chunkier document. That usually sets out the description of the dispute and the parties involved. It'll identify the construction contract that the dispute arises under. It'll identify the adjudication clause in that contract or the statutory right to adjudicate. It'll include when and where the dispute arose, and more importantly, the evidence relied on by the referring party in support of its case. And you'll also have to list the remedy that you're seeking. So flipping that on its head, if you're the party that receives a notice of adjudication, similarly, there's a lot of really important things to consider. But just to kind of give you a few tips is, check, is there a construction contract? What are the terms of that contract? What's the dispute? Has the dispute crystallized? That's all the tick box sort of exercises that you want to be starting with. You want to make sure that the dispute referred isn't a dispute that's previously adjudicated on, because a new adjudicator cannot overrule the decision of a previous adjudicator. You want to check if the adjudicator has been validly appointed, and you want to check whether their jurisdiction can or should be challenged. Referral submissions can be really lengthy and complex. The responding party usually only has 7 days to prepare a response. So time really is of the essence. And as soon as you receive a referral, it's best to seek legal advice, and Mills Selig, can help advise on any sort of jurisdictional points and the adjudication process in general. Once an appointment is accepted by an adjudicator, they will usually have 28 days from receipt of the referral to issue a decision, unless there's a specific timetable in the contract, or unless the referring party accepts any extension to the time limit. And that's really the main benefit of adjudication over court proceedings, because 28 days compared to waiting 2 years to get your case listed is a serious difference. The adjudicator's decision is binding unless and until it's overturned by litigation. The philosophy of the adjudication is that it's quick and it's easy. This means that you must act upon it before challenging it, which essentially means that you pay up and argue later. And if you think that an adjudicator's made an error, you can commence court proceedings to get a final and binding decision on the issue in dispute. If you've lost, however, it's decided that you must pay money, you need to pay the money up before the court will entertain any sort of appeal. And it's the court's decision that will trump the adjudicator's decision. But again, like I said, that could take up to 2 years to obtain. And just broadly speaking, the two most common avenues to challenge an adjudicator's decision are to argue that there's been a breach of natural justice. So that can be where there's maybe bias or procedural irregularity. And the other avenue is to argue that the adjudicator doesn't have jurisdiction. Jurisdiction or the authority of the adjudicator is essentially used to refer to the scope of what they are entitled to decide. So that's the dispute contained in the notice. So again, the notice and the jurisdiction are of paramount importance, because if the adjudicator does not have jurisdiction to determine the dispute, the decision will be a nullity and the court won't enforce it. So moving on to smash and grab adjudications, I just want to touch on these slightly just because they arise quite often. And that's when a payer fails to issue payment notices or pay less notices, and as such, the sum claimed becomes due and owing. So there's a really narrow form of argument here that a notified sum produced by the payment mechanism within the contract hasn't been paid. The true value of the payee's entitlement isn't required during a smash and grab adjudication. However, following an adjudicator's decision, those who successfully refer a smash and grab may be at the receiving end of a true value adjudication. There's a case called S&T Limited and Grove Developments, which highlighted that an employer can only adjudicate on the proper valuation if it has already paid the sums due under the smash and grab. So that case has kind of made it clear that immediate payment is a fair solution because it preserves the builder's cash flow, but it doesn't prevent the employer from raising a further adjudication afterwards to assess the true value of the works. And just when preparing for this webinar, and when I began to think of the three key elements of smash and grab, I was reminded by, I don't know if anyone's seen the film Inside Man with Denzel Washington. In the film, Clive Owen pulls off the perfect bank robbery, and he does so by utilising the key elements of smash and grab adjudications. So number one, speed and surprise. Smash and grabs, they can even often be decided within the 28-day time limit, because often the responding party might have little or no defence. Because what you see is that the responding party will be, if they're unaware of their failure to issue a payment notice or their failure to issue a pay less notice, they will undoubtedly be taken by surprise with receipt of a notice of adjudication. Similarly, in the film, Clive Owen, he has a plan, acts quickly, and takes the bank by surprise in broad daylight. Number two, secure the goods. It's part and parcel with smash and grab that a party that would otherwise not have been paid or would have been paid less money had a valid pay less notice been issued, that they can then run away with a substantial sum. And again, that'll depend on the case specifics, but much like Inside Man, the aim of a heist or a smash and grab is the exact same. And three, make a quick getaway. The courts are generally happy to uphold a smash and grab decision provided it's been made regarding interim application. So it's therefore unlikely, but not unheard of, for a responding party to succeed in challenging an adjudicator's decision. Clive Owen makes the perfect getaway. He tells Denzel, who's the detective, throughout the film that he plans on leaving the bank the same way he came in, which is through the front door. And he does exactly that, dressed as a civilian. So similarly, a successful smash and grab will result in the referring party walking straight out the front door with the goods. But just as a disclaimer, I'm in no way calling smash and grab adjudications robberies, but you can see how the same principles apply. And I think it's important, therefore, to consider, how do the short-term and strategic benefits of receiving payment compare to the cost and effort of launching and then possibly defending adjudication proceedings. And it's worth mentioning that if you're going to adjudicate on a technicality, so namely no pay less notice or no payment notice, you ought to be able to demonstrate that you followed the contract to the letter. So that's particularly relevant, when an adjudicator is assessing your application for payment. So please take care, adhere to all the relevant specifics of the contract concerning notices and applications, because an adjudicator may well take a forensic view on issues, given the nature of this dispute referred to them. So, in other words, if you're going to take a swing, make sure you don't miss. And just to conclude, I'll give you a few takeaway points. Would be just get expert advice from the start. Whether you're commencing or defending an adjudication, everything you do could determine your rights within the process. So one wrong move could result in a losing case. Win or lose the adjudication, you're going to be responsible for your own costs. That's always going to be the case. The adjudicator will decide who pays their fee, which is usually the losing party, but that's not always the case. And parties will be jointly and severally liable for the adjudicator's fee. And like I mentioned, adjudication allows the parties to obtain an enforceable decision within quite a short period of time, and it's at a fraction of the cost of litigation. The referring party is largely in control, because usually it will spend months preparing its case, just like Clive Owen spent ages preparing the bank robbery, and then the receiving party or Denzel, they only have a couple of weeks to respond and manage the situation. And adjudication rarely has any oral submissions, but detailed written submissions, including expert witness reports or witness statements, may be required. And that's where the devil is in the detail, because what may seem like a really simple, straightforward case on the face of it, whenever you get bogged down into the real detail of the case, that's where problems, can arise and surface. So it's always good, how much you can evidence, how much you can demonstrate to the adjudicator to back up your case will really help you in the long run. So that's everything from me.
Fantastic. Thank you, Rebecca and Conor. That was really useful. Great insights. If anyone does have any questions, please feel free to pop them in the chat. And I'll see if there's any here now at the minute. So one question is, can you refuse an offer to mediate, adjudicate, negotiate, and proceed with the court proceedings? What would be the consequence of that?
I guess I can answer part of that. So I guess the question's really whether can you refuse an offer to engage in ADR and proceed with your litigation and go all the way to trial. Like I say, the conduct of the parties is always taken into account at the end when it comes to costs, but it's also just something to bear in mind. Even if you think that mediation would be a waste of everybody's time, nobody's willing to budge, or the other side is taking a really unreasonable stance, it may well just be worth doing anyway, so that you do protect yourself down the line, to show that you've been the reasonable party. And that's how we would tend to advise clients. But if the other side are trying to they're trying to make conditions on your mediation, for example, that would be unreasonable, and you'd be in your rights to reject an offer to mediate. There shouldn't be conditions based at all. Those parties should be able to go in and be free to make whatever decisions they want under whatever circumstances. But yeah, it's something to bear in mind when it comes down to the costs at the end. I'm not sure if this. I assume the same would apply to arbitration, but whether that comes into with adjudication, Conor, I guess you could pick up on that.
Yeah, I'm probably just going to give the typical lawyer answer of I'd want to see your contract, because like I said in the slides, like you're going to have, whether an adjudication clause is in your contract or not, that'll depend on whether the parties partake. But even if it's not included, then you've a statutory right to refer your dispute to adjudication. So regardless, if the other side issue adjudication proceedings against you on that basis, you're going to have to either decide not to take part and defend your case, or what I would obviously recommend you do is get sufficient legal advice and prepare your defense.
Okay, super. Thank you both. There's no further questions at the minute, so if everyone's content, I think we can draw to a close there. Thank you to Mills Selig, our legal patrons, for their guidance in this, and thank you to everyone for attending. Thank you. Bye bye.
Thanks.
Thanks for having us.